This video is for research and educational purposes only. Today, we'll look at Vincent Ooi's 2022 article, Contracts Formed by Software, an approach from the law of mistake, published in the Journal of Business Law. Written from the perspective of common law and drawing on case law from England, Singapore, and Australia, as well as international instruments, this paper examines how the law can address the challenges that arise when software autonomously enters into contracts. The paper begins with what Ooi calls the contracting problem. Under the objective theory of contract, a binding contract requires each party to exhibit an objective intention to be legally bound. But when software forms contracts without human input, the contracting parties may be entirely unaware of the specific terms agreed upon. In such cases, no objective intention can be inferred, and theoretically, no binding contract is formed. To solve this problem, Ooi reviews three proposals: the mere tools theory, the agency approach, and what he calls the extended objective theory of contract. He argues that only the third proposal offers a viable solution. The first proposal is the mere tools theory. Under this theory, software is treated as a simple communication tool, and any representation it makes is deemed to be a representation of the user. Ooi distinguishes between passive contract-forming mechanisms, like email, which merely relays the user's message, and active mechanisms, such as robo-advisors and algorithmic trading systems, which make autonomous decisions about whether to contract and on what terms. Ooi accepts that the mere tools theory works well for passive mechanisms. However, he argues that it becomes an unrealistic fiction when applied to active mechanisms, where the human operator's role is limited to setting general rules or objectives. He further criticizes the theory for being a blunt instrument that unfairly allocates risk. Under this theory, the user would be bound even when the software acts in such a wildly irrational manner that the other party could not possibly believe it was functioning normally. The second proposal is the agency approach, supported by writers such as Chopra and White. This approach treats software as an independent, electronic agent with separate legal personality and applies agency law to attribute the agent's acts to the user as principal. Ooi acknowledges certain strengths. The doctrine of authority can limit the scope of the user's liability. The doctrine of ratification allows retroactive approval of unauthorized contracts. And there's an argument from economic efficiency. Risk is allocated to the least cost avoider. However, Ooi identifies fundamental problems. Electronic agents cannot consent to an agency relationship. Fiduciary duties cannot be imposed on software. And since electronic agents lack legal personality, third parties cannot sue them for breach of warranty of authority. Ooi also advances a philosophical argument. He contends that agency as a concept is premised on the agent's capacity for free will, specifically, the intrinsic potential of a sentient being to conceive of a counterfactual, that is, the possibility of not acting as instructed. Any meaningful concept of intention to be bound requires the entity in question to have what Ooi calls the faculty simpliciter, the bare capacity to conceive of an intention not to be bound. Software lacks this capacity entirely. Finally, Ooi notes that applying only the external aspects of agency while stripping away the internal aspects, consent, fiduciary duties, moral responsibility, would create inconsistency within the law of agency itself. He concludes that the agency approach is ultimately unworkable. This leads to Ooi's preferred solution, the extended objective theory of contract. Drawing on Allen and Whittison's 1996 proposal, Ooi suggests that courts should recognize a generalized and indirect intention to be bound by computer-generated agreements. In other words, by choosing to deploy contract-forming software, a party expresses a prior intention to be bound by all contracts within a certain class or type that the software enters into, rather than by each specific contract. The test of reasonableness is adjusted accordingly. A contract is binding so long as the promise made by the software can be reasonably inferred by the counterparty to fall within the generalized intention of the user. Ooi offers several justifications. First, fairness. Since the user chose to employ the software, he should assume the risk. Second, certainty. Applying a subjective standard would make it impossible for the counterparty to know whether the software was acting in line with the user's intention. Third, this is an incremental development consistent with the common law's long history of adapting to new technologies, from the postal acceptance rule, through telex and fax, to vending machines and e-commerce. Ooi also draws an analogy to unilateral contracts. Just as the owner of a vending machine is inferred to have a general intention to be bound by all permutations of transactions the machine can handle, so too should users of active contract-forming software be treated. He further notes that international instruments, such as the UN Electronic Communications Convention and the EU e-commerce directive already mandate that contracts should not be denied validity merely because they were formed by automated systems, though he observes that these instruments do not themselves provide the theoretical basis for attribution or rules for risk allocation when things go wrong. Having established the attribution framework, Ooi then turns to the law of mistake to address what happens when software malfunctions. He distinguishes between orthodox cases, where software is involved but not the source of the dispute, and software-specific cases, where the dispute arises precisely because the software produced an unintended outcome. For unilateral mistake, where only one party's software malfunctions, the standard common law requirements are: the mistake must relate to the terms of the contract, it must be fundamental, and the non-mistaken party must have had actual knowledge of or been willfully blind to the mistake. The effect is to render the contract void ab initio. But in software-specific cases, Ooi identifies a critical problem. The non-mistaken party only receives the software's output and has no access to the mistaken party's subjective intention. The non-mistaken party is entitled to presume that the software's representation reflects the user's true intention. This presumption is only rebutted where the non-mistaken party knew the user had not intended to contract on those terms. The difficulty deepens when both parties use software. It is artificial to say that software can possess actual knowledge or display willful blindness. The third requirement of common law unilateral mistake could, in theory, never be satisfied in a fully automated contracting scenario. Ooi's solution is to shift from common law mistake to the doctrine of unilateral mistake in equity. Under equity, the standard is constructive knowledge, whether the non-mistaken party could reasonably have been expected to discern that a mistake had been made. And the effect is that the contract is rendered voidable rather than void, which better protects innocent third parties and preserves the stability of high-volume automated transactions. Ooi argues that this approach is also economically efficient. When a mistake is obvious, it is cheaper for the non-mistaken party to flag it than for the mistaken party to continuously monitor every output of its software. When the mistake is not obvious, the burden rightly falls on the mistaken party to verify. He briefly addresses mutual mistake and common mistake as well. Mutual mistake, where both parties' software simultaneously malfunction in different ways, would be exceedingly rare, and standard principles rendering the contract void ab initio would apply. Common mistake, where both parties make the same mistake, perhaps because they use the same platform, can be handled by ordinary common mistake principles. In conclusion, Ooi argues that the extended objective theory of contract is the only viable solution to the contracting problem. It requires a logical progression of the common law to accept that parties may agree in advance to accept contracts entered into by their chosen software within preset parameters. When combined with the law of mistake, specifically unilateral mistake in equity, this framework places the risk of software failure on the user, except where it would be unreasonable for the counterparty to take advantage of a clear mistake. Ooi presents this as an approach that is simple, intuitive, fair, and promotes commercial certainty. That's our overview of Ooi's 2022 article. Thank you for watching.